Hello, everybody, and welcome to the 12 CEUs of Christmas. Today, I'm joined by Wendy Stevens, my colleague. Wendy, how are you doing?
I'm doing well, Diane. How are you today?
I am great. I can't believe how busy the holiday season is, and I think as you get older, everything speeds up. So it's just kind of crazy. How's it going for you as far as buying, shopping, packing everything up for the holidays?
I'm doing pretty well. I think I'm all finished with the shopping phase. I'm the Christmas wrapper that everybody doesn't like because I don't use bags. I wrap everything up and I put pretty ribbons on them and dress them all up to make them look pretty. And I have a little teacup Yorkie named Dozer, and he inevitably goes under the tree and finds a gift, and then he unwraps it. He just deconstructs and unwraps, and I feel like it's just one more opportunity for me to wrap another gift.
Well, getting a gift from you is like getting artwork because you do a beautiful job. I can't say I'm in that camp. Is there anybody else that loves to wrap? If you do, go to the question box and let us know if you love to wrap. Because I'm a bag person. You can put in there bag or wrap, and we'd love to see what you have to say. Oh, look at that, Emily. She's with you. She's all about the wrapping. Stephanie's about wrapping as well. That's awesome. I'm a bagger. Oh, look, I got Sandra and I are seeing eye to eye on that. So it is very fun when we can see this and see what other people are doing. Oh, hi, Marietta. She also loves to wrap. All right. So before we get
So
started, go ahead.
one more little tidbit. Sorry, Diane, didn't mean to interrupt. One more little tidbit. When I was in high school, I used to wrap presents for people, and I would charge $1 a package. And that's how I paid for Christmas presents when I was in high school.
Oh,
So
that's
my love
well,
started with
that's very industrious, right? I need a way to do that. I see Elaine loves to wrap as well. It's so nice to see so many of you guys that we know on today's webinar. So if we're going to give some housekeeping, but I'm going to keep watching you guys' comments. So today we do have an elf-tastic webinar. We have a great speaker. So we want to make sure that you know that you'll be receiving your CEU within 1 hour at the end of this presentation. If you have a problem with it, make sure that you reach out to your IT department. It is usually a firewall issue. And also, too, something new is I can help you in the first 30 days. If you don't download it or something within 30 days, I'm not going to be able to help you. So make sure that when you get the notice that you do that immediately so that we can help you if there is an issue. And then if you have any questions for our expert, you could put it in the question box where you guys have been putting whether or not you like to wrap or bag. So do that. Also, too, we have handouts. So make sure that you download those handouts so that you can participate in that. And then lastly, there is an encore performance of this, and you can watch it on the Macro Pro YouTube channel. And like it says here, like the movie Elf, it's worth a second look. So by all means. Now, Wendy, can you tell us who our speaker is today?
Our speaker today is Nancy Hill, and she's with Sullivan Law. Nancy spoke for us last year with our 12 CEUs of Christmas. Hi, Nancy. And she was very popular, and people did watch her presentation a second and third time. So I'm going to turn it over to you, Nancy. But before I do that, do you have any holiday or Christmas traditions that you enjoy? Not
Gosh,
wrapping gifts.
I was going to say I'm definitely a bagger. I avoid wrapping at all cost. Takes way too much time and energy. Plus, I have a couple of kids, so there's a lot of presents involved. So I definitely spend more time putting things in bags than wrapping them for sure.
And that works beautifully. Nancy, I'm going to let you take it away.
Sounds great. Thank you so much. I am going to get things started here today. Here we go. So let's get my little mouse out of the way here. So today I'm going to be talking to you guys about PD rating, so the different rating schedules, combined values charts, and the Kite decision. So just as a precursor as we get things going, you can see this is myself, yay. I'm a partner at Michael Sullivan and Associates. I've been there a little over 4 years now. Absolutely love working there and love the people that I work with. Wouldn't change it for anything. A little bit about where I work. I think a lot of people already know this, but we actually have several different departments, one of which being workers' compensation claims that we cover. We also now have an employment department. We work in insurance litigation and subrogation as well, so we have a specialized subrogation department. And more recently, we opened up an audit department. So we can help assist different TPAs and carriers with audit situations. If they're being audited, we can actually come in and help with that now. So we have a specialized unit for that coming out of Fresno, I believe, our Fresno office. As you can see here, we are all over California, El Segundo, Fullerton, so Southern California, several offices, Fresno, and then I'm up out of the Oakland office. We have Sacramento, San Jose, and Redding as well. I specifically take a lot of my cases out of Santa Rosa. That's my specialized board. And I think, as everybody knows, we also wrote the book on comp, Sullivan on Comp. I'm not sure if it has happened yet, but I know it will be happening soon if it hasn't already. We're going to be discontinuing the paper books, which kind of makes sense to me. It'll be only online. And I think that's a lot of people do things mostly online anyway. So let's go over a little bit of what I'm going to talk about today. So permanent disability, how it's rated. So we'll go through kind of some different ratings, as well as looking a little bit back at the 1997 rating situation. Then we're going to look at how that impacts apportionment, and then go a little bit through the combined values chart, as well as how that works in a rebuttal to that with Kite, and then discuss how Kite is applied. Throughout this entire presentation, although it does say questions and answers at the end, I'd prefer just pipe up. Go ahead and type in a question. Wendy will be watching that for me, and that way I can kind of talk throughout instead of having me do it at the very end. So please let me know. As we're going through the permanent disability schedule and looking at rating specifically, if anybody has their rating schedule with them or handy, might make it a little bit easier for you to understand what I'm saying, but I will go through it slowly, so hopefully you guys can keep up with me. So I think all of us pretty much understand permanent disability being, where the person gets to at maximum recovery and where that person's going to be once they're permanent and stationary. So that's their impairment that they're going to be left with. Now, as a lot of us know, the AD basically put together this disability rating schedule and said, we need to have under 4660 and 4660.1 an actual rating schedule in order to promote consistency. So we needed to have a way for this to be uniform and objective, so we could compare two people's injuries and be able to understand how they are different or how they are the same. And hopefully, if a person is reviewed by two separate doctors, in theory, we should get the same permanent disability rating out of it, right? So let's look at the two different rating schedules that are still in effect at this point in time. We have the 1997 PD schedule and the 2005 PD schedule. Now, fortunately, the 1997 PD schedule is very rarely used at this point because it's only for injuries that occurred before January 1st of 2005. Now, I'll go into a couple of exceptions when we go a little bit farther on. But at this point, most of us are using the 2005 PD schedule, which is for all injuries that happened after January 1st of 2005. Now, there's a couple of instances in which we'll end up still back on the 1997. So there is two different parts. So one of them is if we end up with a med legal report, either by a QME doctor or by a treating physician, basically before January 1st of 2005, that said that PD existed, or if we have the defendant who had to have a notice sent, so TD ended, and the 4061 notice was sent out before January 1st of 2005. So just as kind of a quick reminder, and we'll go through it a little bit more, the 4061 notice is the one that is sent when TD ends. So sometimes this happens where they've run out of TD at this point in time, but it's too soon to tell if they have permanent disability. Or we have a situation where it's sent out and the person has no permanent disability, or we believe they don't at that point, but they may not necessarily be PNS at that point. If either of those exceptions apply, then we're still going to be back under the 1997 schedule. So now looking at these exceptions in a little bit more detail. So first we're looking at the med legal report or the PTP report that basically says there was some version of PD before we hit January 1st of 2005. So we kind of have split court decisions where the requirement would be under the first one, Vera versus the WCAB, that person needed to reach permanent and stationary status before that point in time, or they would not be underneath the 1997 schedule. Under the second group of cases that we're looking at right here, there's actually several of them that said, no, in fact, the permanent person does not have to be permanent and stationary at that point in time for the 1997 schedule to apply. They just had to have had the 4061 notice go out, so the temporary disability ended, the 4061 notice went out, whether or not the person was actually permanent and stationary. So that's that second situation I was talking about where TDs ended, but you put out a too soon to tell notice regarding PD. And it turns out at this point in time, the WCAB has pretty much decided or taken the position that the person doesn't necessarily need to be permanent and stationary before January 1st of 2005 for the applicant to be under the 2005 PD schedule. So that's kind of how it's fallen at this point in time. Fortunately, at least for myself, and I think a lot of us, we don't have any of these 1997 schedule cases left. Now, looking at this exception at this point in time, just a little more detail, and I may have gone into a lot of it already. It also applies, when that notice is sent out. Like I said, it would be the 4061 notice is the PD notice that is sent with that last issuance of temporary disability. Now, if the TD benefits were terminated before January 1st of 2005, then that PD is going to be rated under the 1997 schedule. We have a series of cases to talk about it. So we'll look at these a little bit closer and the difference between the two different PD schedules. So biggest thing is that the 1997 and the 2005 schedules are looking at a standard rating. So the idea is that we're trying to create a consistency under each of them. Now, the 2005 schedule uses the AMA guides in order to support their issuance of disability. And we're using a whole person impairment that has been provided by the doctor under the AMA guides. Now, when we're looking at the 1997 schedule, they were using actually a couple of different situations. One wasn't used nearly as often, but was still available. And that's when they took a objective and subjective index provided by the doctor. So using things like range of motion, which we currently use under the 2005 PD schedule, but they used it with a subjective index of pain as well to try to come up with a degree of impairment, where normally under, or more consistently under the 1997 schedule, they actually used a work capacity mode, which was usually work restrictions that would result in a PD rating. And here's kind of an example of how that standard work capacity ratings would work. And I think a lot of us still hear this language used in folk rehab reports and things like that. So sedentary work, light work, heavy work would then pump out a specific rating that was then used at that point in time. Now, when we're looking at the 2005 rating schedule, which is what a lot of us now use and work on, it's kind of two different situations that we want to look at. It's whether or not the injury happened before January 1st of 2013 or after January 1st of 2013. And when I was first thinking about that, I thought, well, January 1st, 2013, that wasn't that long ago. But now that I really sit and think about it, it was actually 10 years ago. So I'm finding fewer and fewer of my cases that come up actually still deal with the DFEC, the diminished future earning capacity adjustment. So if we're looking at 2005 PD schedule ratings, we then need to ask ourselves the second question, and that is, was this injury before or after January 1st of 2013? And this is where, as I start to go into this, if you have your rating schedule with you, this will get a lot easier for you to understand if you're able to look in your rating schedule, or at least to follow along. So with going through the adjustment of the WPI, or the whole person impairment rating that's provided by the doctor under the AMA guides, this is what you're going to look at to be able to adjust that whole person impairment rating into a permanent disability rating that's then going to equate to that dollar amount that would be provided to the applicant. So you're given a numeric code or digits that's going to be your impairment number, right? And each of the spots under the numeric code actually provides information regarding what method was used by the doctor in order to get there. So looking at the ones that I've provided as examples, the first 2 digits are going to be the area of the body that we're looking at, which also correlates to the chapter of the AMA guides that you're looking at. So if we're looking at the spine, which would include the cervical, the thoracic, and the lumbar spine, you would be in chapter 15, so it would start with 15. The next set of digits, the next 2 sets or next 2 digits are going to be what part of the spine we're looking at. So 03 is the lumbar spine, and there'd be a different number for the cervical spine or the thoracic spine. Then you're going into the next 2 digits of this numeric code, and you'd be looking at what type of method was used by the doctor to provide their impairment rating. And I think it's fairly easy for us to all understand whether or not the doctor used the DRE method or a range of motion method, or if they use a combination of both or a other method, you'd use a different code under that. So from this string rating from the AMA guides, basically you get different categories and different things that come up. So if you're looking at the DRE category, the doctor will provide, for example, a 20% WPI from a DRE category 4. Alternatively, they may go through and the doctor might go through a range of motion method and provide a different level of impairment, such as a 25% whole person impairment. And from there, this is where you often get a lot of the arguments regarding whether or not the doctor actually provided the correct impairment from there that would then be adjusted to give the permanent disability rating used for settlement. This is where a lot of the negotiations, the arguments come in as far as whether or not it was appropriately applied. Because when you're looking at the AMA guides, there are several places and rules and expectations that are placed out there, but also a lot of leniency is given to the doctor to provide the best impairment that they believe accurately reflects the limitations on the applicant's activities of daily living. So you add on top of this layer Alvarez-Guzman, which is a case that came down. I'm not going to go into a whole lot of details because we'd have to have a whole nother hour's worth of time to talk, but allows the doctor to go outside the strict rating under the AMA guides and analogize to another area of the AMA guides that they believe more accurately reflects the impairment that the applicant is having at that point in time. And a really easy example of this is, well, let's start with the fact they must stay within the AMA guides. But a very easy example of this is when we're looking at the lumbar spine. Doctors often will go to the hernia category with lifting and go immediately to a place like that and say, well, although they don't have a hernia, they have restrictions on lifting. And now they've jumped to a completely other category that has absolutely nothing to do with the thoracic or the lumbar spine, but they're able to provide impairment under that area as long as they justify the reasons for going to a different area of the AMA guides. Now, the next thing we want to look at is, as we're going through this string rating, is the diminished future earning capacity. So when we were looking at injuries that happened prior to January 1st of 2013, this whole person impairment rating needs to be adjusted based on this person's future earning capacity. So depending on the type of job that they had, this would be, depending on the body part that we're talking about, this would be adjusted differently depending on what that person was doing. So for injuries before January 1st of 2013, the DFEC adjustment was different depending on body part. So for example, a knee was rank 2, wrist was rank 4, psych was rank 8. Each of these would be an increase depending on which rank you were in, between 10% and 40% of what their original WPI was provided. Now, after January 1st of 2013, instead of having this adjustable DFEC situation, they went ahead and pulled that out and said, you know what, we're just going to go ahead and increase every whole person impairment rating by 40%. So it made going through the process of adjusting the whole person impairment rating much more simple, because you didn't have to look up this particular step in the process of providing a rating. The next thing that you're going to look at is the occupational impact that a whole person impairment rating has on the person's occupation. So the reason this matters is, for example, and it's provided here on the slide, a person who loses their hearing is going to be affected far more if their job to go to work is an attorney, because so much of our job has to do with listening, providing responses, taking an impact, things like that. Whereas for a gardener, when they go to work, they may not necessarily need to be listening to people taking in information and providing responses. They can go to work, and not actually have to talk to anyone. So that's something that's important to take into account. Now, as it shows in the alternative, if the injury is to a shoulder, I can probably still do my job fairly well without needing to use my shoulder to any great extent. But if I was a gardener, this is going to become a very big issue for me. So this part of it, and if I was able to show you the rating schedule, we could take a look at how it changes for each person. But this particular part of the rating schedule is adjusted depending on your occupation. So each one will change depending on what's going on and which rating or which adjustment would apply to which job. Another part that needs to be taken into account is that jobs have different levels of activity within them. So let's say your job could put you in several different categories. Some days you're sitting at the desk, and other days you're out doing heavy lifting or climbing up high to high places to wash windows. If you could fit into multiple different categories, they're always going to place you, the WCAB is always going to place the applicant in the highest possible occupational group that they can, assuming that that is where probably the injury happened, or that you would be, your highest loss of capacity for earning is happening. So the PD schedule is basically used to match up those two things to make sure that the adjustment is done properly. And that's another also place where it is interesting to see a lot of litigation happens over trying to adjust the permanent disability rating up by selecting higher occupational groups based on the activities that the applicant does at work, even if it's not necessarily listed in their job description. I've found many times that applicant attorneys will look to what they actually participated in at work versus what was written down on their job description to show that they belong in higher occupational groups to increase the PD rating. So looking at them, as that previous slide said, and I'm going to go through these fairly quickly because I don't think we need to look at every occupational group. But what you'll notice with these as we look through some of them is that the lower numbers are going to be the lower activity groups. They're going to be the less strenuous groups that you need to be a part of, but sometimes they're going to be the ones that actually require more particular skills, for example. And you'll notice that the skill level goes up with the last numbers in the 3-digit code. So the first numbers of the digit code of the 3-digit code relate to the strenuous nature of the occupational group that we're talking about. And the last digits of it actually start to talk about the particular nature of it and the detail involved in being able to be a part of that particular job. So one of the ones I like to take a look at is looking at 214, for example, which is clerical but with physical activity. And the 214 with the 4 at the end, you're looking at someone more like a teacher, somebody who has to have a little bit more information and experience in that. Going down the line now, we're looking more at in the 200s to the 300s. You're getting more into people who are doing cleaning, people who are working in breweries and things like that, in a cellar worker. As we get even farther up the occupational groups, we're looking into 300s and the 400s. These are people doing skilled construction work, heavy laboring, things like that. And then getting way up into the top, I very rarely deal with applicants up quite this high. I think I get into the 490s sometimes. I don't think I've ever dealt with anybody in logging at this point or fishing. But 491 agricultural, I do deal with that a lot. And then you have all the way up at the very top, professional athletes, things like that up in the 590s. Okay, so one of the last things that you're looking at when you're adjusting your string rating is the age of the person at the time of the injury. So what the AD has decided is that the kind of mid-standard age rating is going to be 39. So generally when you're looking at that, somebody who's a couple years younger or a couple years older is going to have a change in their PD rating based on that. So as the person gets younger, their PD rating is going to decrease, and as the person goes up from the age of 39, their PD rating is going to increase. All right, so here's where if you were able to look at a rating chart or your rating schedule, that it would be helpful for you to follow along, but I'll go through it with you guys so you guys can kind of see how this works. So this particular example is a 30-year-old furniture mover with a 2012 date of injury resulting in an 8% WPI for the low back under a DRE category 2. So we're going to go through what the string rating would be. So if you first look at the string rating itself, the 15 goes to the fact that we're talking about the low back or the spine. The 03 gives it the lumbar spine, and the 01 gives you the fact that it's under the DRE category. Next part we're going to look at is the 8%. So if you see at the very bottom of the slide that I'm looking at right now, we're going to put the 8% in there. And now because of the fact that it is the lumbar spine back before January 1st of 2013, because this is a 2012 date of injury, we have to look up what the DFEC ranking would be for the lumbar spine, and that's a 5. So based on the fact that it's a 5, that 8 then becomes a 10 based on its adjustment level. Now we're looking at somebody who's a furniture mover, which puts that person up in the 560 occupational code. So the adjustment for a 560 for the lumbar spine gives us a J occupational variant. So if you look under the rating schedule for the J, a J would then increase that 10 WPI up to a 16. Now we got to look at the age of the applicant because we're going to make the adjustment for age at this point, and the person's only 30 years old. So because of that, we're going to go ahead and knock that impairment down from a 16 to a 14% PD rating. Now we're going to look at another example. And again, if you had your rating book, it would be a little easier to follow along, but hopefully you can keep up with me on this. So in this particular case, we're looking at a 60-year-old truck driver with a 2015 date of injury. So now we're looking at something that is after 1/1 of 2013 that resulted in a 30% WPI for the low back under a range of motion method for spinal stenosis with surgery. And now we're going to look at how we would adjust this one out. So again, looking at the string rating, the 15 goes to the fact that it is the spine. The 03 goes to the fact that we're looking at the lumbar or the low back. The 02, different than before, because now we're looking at a range of motion method for adjusting. And the 04 is because of the fact that it was spinal stenosis with surgery. And the next thing we're going to look at is that we're adding in the 30. If you look down at the very bottom of my slide at this point, we're looking at 30% WPI because this is post 1/1/13, because this is a 2015 date of injury. We're going to automatically adjust by 40% up or multiply it by 1.4, which gets us to a 42% rating at this point. The gentleman was a truck driver. So truck driver provides an occupational code of 350. And when we look at a 350 for the lumbar spine under a DRE method, under a range of motion method, we get a G as the occupational variant, which would bring that 42 up to a 45. And now we're looking at the gentleman's age, which is 62 years old. 62 is substantially up from 39 years old. So the variant moves up, the impairment moves up from 45 to 55% PD. So hopefully that gives you a visual understanding of how the string rating is adjusted to take into account the occupation, the age, etc., in relationship to the body part and what the applicant did for a living. So one of the next things that comes into play when we are looking at, now that we have this, impairment or disability provided that's been adjusted after the impairment was provided by the doctor, the next thing we want to look at is apportionment. So after the permanent disability has been adjusted, not the original WPI that was provided, we now have, and when I say we, the defendants now have the burden of proving whether or not there is any apportionment involved. So we're going to come in and look at what that final rating is and what we can do with that. One of the most important things about apportionment is that the doctors need to justify their apportionment in their reporting. So we need to be able to show how whatever apportionment has been provided has been justified as far as the differentiation between its industrial relation and its non-industrial relation. So in this particular situation, a doctor apportions 50% to a back disability injury and 50% to degenerative disc disease. So you'd really want them to talk about objective evidence of the degenerative disc disease, like MRI findings, specifically findings from far before the specific injury if you have one, or things like that, so that you can show this impairment existed before the injury itself, the work injury itself. So here's an example of how this would be applied and why it makes such a big difference in what's going on. And I think a lot of us have seen this. So if you have this string rating that we were just talking about that rates out to 55%, but the doctor comes in and apportions 50% of this away, we've now broken this down to 28% PD. And I think I want to point out here a note on that. If anybody picks up that 55% divided in half is not actually 28, it would be 27.5. But if you ever end up with something at a 0.5, you always round up to the benefit of the applicant, just as a note. So the reason this is really important is that PAD benefits don't rise in a linearly appropriate way. It's actually more on a curve, right? So what you're looking at is that a 28% PD rating, which would be half of the 55% and actually slightly more than half, is actually only worth $34,437 and some change. Whereas had the applicant been able to hang on to that full 55% with no apportionment, you're looking at a $90,000 plus award for benefits. So apportionment can really significantly change the outcome of a doctor's opinion one way or another, or the permanent disability rating that ends up being considered industrial. So here's another thing that we want to look at, is looking at the combined values chart. So now we've looked at how we end up with permanent disability ratings. And oftentimes I think we've all learned that you don't end up with just one injured body part. I think oftentimes you end up with several body parts, whether it be from multiple injuries from the same incident or an injury and then some compensable consequences that like to get tagged on. So from there, we have the combined values chart. So this was designed to make sure that multiple impairments can be combined together instead of added together in order to create a value that is less than the complete sum of all of the parts. And I think one of the most important parts of this was to make sure that nobody ends up with a sum total of impairment or permanent disability that equates to more than 100% PD. Because as we start to end up with more and more permanent disability ratings, these can end up, depending on which body parts we're talking about, at a combined value or an added value, I guess I should say, at much more than 100%. But the combined values chart basically combines two values of multiple impairments to a summary total that is less than what they would have been added together. So here's some examples of this. So 30% disability for one body part and 20% disability for another body part under the combined values chart would actually only be 44%. But we both know adding these two things together would be 50%. And here's, as you know, we're looking at trying to avoid getting to a place where we would be pushing close to 100%. If an applicant has 40% disability for the back, 30% for the neck, and 20 for the left knee, we combine these together, 40, C30, C20, and we only get to 66%. So this is obviously something that most people believe is employer friendly or defense friendly, because it does make sure that we don't end up in a place where what this would have been is 90% if we combine or we add 40 and 30 and 20. So it's important to note, though, that the AMI guides don't actually mandate the use of the combined values chart. And I'm actually going to read this through because it's fairly important to note what it actually says. So it says a scientific formula has not been established to indicate the best way to combine multiple impairments. Given the diversity of impairments and great variability inherent in combining multiple impairments, it is difficult to establish a formula that accounts for all situations. Many workers' compensation statutes contain provisions that combine impairments to produce a summary rating that is more than additive. Other options are to combine, add, subtract, or multiply multiple impairments based on the extent to which they affect an individual's ability to perform activities of daily living. But it says on page 1 through 10 of the PD schedule, it states very specifically, impairments and disabilities are generally combined using the reduction formula. So there are several different places within the AMA guides where it indicates that you're to combine certain things. And there are other parts under the AMA guides where there are addition used before getting to another step in the provision of providing whole person impairment ratings. And so it is made fairly clear that the CVC is, or the combined values chart, is the preferred method, but not the only method to be providing impairment under. So one of the things we want to look at, though, is how did we get to this place where people started adding instead of combining? Because this was actually far more recent. Well, 2013. Again, I feel like it's very recent, but it's actually 10 years ago. There's a case called Kite, and I think many of us have heard of it. And this is a situation where the applicant sustained injury to their bilateral hips. And the QME in this case provided a 20% WPI, a whole person impairment, for each of their hips. And the QME ended up indicating that the best way for this impairment to be provided to the applicant was to add them together instead of using the CVC. And the QME goes into specific language that I think a lot of us have heard, is that there is a synergenic effect of the injury to the same body parts bilaterally versus body parts from different regions, and that adding these impairments for both of the hips produces the most accurate reflection of the applicant's PD. So the QME in this case basically points out that because both hips, so bilaterally, are injured, this together synergetically affects the applicant in a greater way than if the applicant had had an injury in two different places that didn't necessarily affect it in the same way, like one hip and a different body part. And I think the key term here, and you'll start to see it on repeat as I go through more of these examples, is that synergetic effect. So here, the WCAB ended up upholding the judge's decision of awarding the 46% PD, but after adding together the two impairments instead of combining them as normal. And the reason they did is they said, you know, there shall be a prima facie evidence of percentage of permanent disability to be attributed to each injury covered by the schedule. And in this particular case, the guides indicate that there is a preference towards being combined, but each person can employ different methods to go ahead and do that. And so under these circumstances, they said because of the left and the right hip injury, it was okay to proceed like this. And from there, the doors were open to a floodgate of many other cases. So interestingly, this is not necessarily a binding decision because the appellate court denied review of the petition for writ of review. So at this point, it has just kind of been set out there, but it hasn't been challenged to the point that it's been set out there to actually be a binding decision. But ever since then, now people cite to Kite and even request from QME doctors that they consider Kite as well as Almaraz-Guzman, which we discussed a little bit earlier, in order to push for that increase in the PD rating to figure out how, under the circumstances, to try to negotiate with the doctors a higher level of permanent disability. So looking at Kite, so basically, fortunately, I guess you could say, fortunately, under the Kite decision, they did actually go through, like what I was saying earlier, is that the AMA guides do express and indicate that they have a favor towards the CVC as opposed to using the adding method, but it's still something that is allowed. The unfortunate thing is it's the applicant's burden to prove that the CVC should not be applied and that addition is the appropriate way to do this. So we're going to go ahead and look at some cases that they have talked about whether or not Kite was appropriate or not, and why. So here we go. So one of the most important things is that substantial medical evidence is required. So a departure from the CVC is not required every time a doctor says that things should be added. The doctor's opinion actually still has to be substantial medical evidence. It has to be supported by scientific reason. The WCAB will allow disability to be added rather than combined, but it comes down to whether or not the doctor actually explains themselves and whether or not the judges find that compelling, that support compelling. I think it's also important to note that each judge or commissioner is going to look at what evidence and what reasoning has been provided by the doctor, and from there make up their own mind. And this is where things get a little bit more frustrating, is that one doctor or one judge may find a doctor's reasoning compelling when another judge may indicate that it's just not quite enough. And so here's some examples, and I think this is where it is important to see the language that is used in the cases that did allow disability to be added. And I want to read just a couple of them to kind of point this out. One of them is Markowitz, which basically talks about the fact that disability is combined by addition based on an AME's opinion that there is a synergy between the lower extremities and the lumbar spine and is more appropriate to add the impairments. So this is what the doctor's language was that the courts found was sufficient to allow addition of impairment between the lower extremities and the lumbar spine. To me, that's a little bit dangerous because I think we often have lower extremity impairment combined with the lumbar spine in many, many cases. And just adding in language using there is synergy between the two seems like light reasoning as far as I'm concerned. Here's another overall versus the city and county of San Francisco. And here's one where disability for the right knee and both hips combined in addition because the AME reported that these body parts worked in synergy, and therefore it is medically reasonable on a purely medical basis to say that the injuries are inextricably intertwined. And here's another one of those really fun terms that often are used by the doctors in order to either frustrate the ability to parse out apportionment, or in order to pull in body parts like this and create a situation to add the body parts instead of combine them. And here we have last one on the cases allowing disability to be added. Here's a psychiatric case and an orthopedic disability case where the AME reported that the disabilities do not overlap and that their synergistic disabling effect on the applicant's earning capacity support addition of the disability values in order to obtain an accurate overall rating. This again to me is a very interesting and kind of scary one, adding the psych overlap on top of the orthopedic disability and then being able to add those two instead of combining them, partially because we're looking at a mental issue and an orthopedic issue, and we often have these two overlapping in many different cases. Now, here's a few cases that they didn't allow the disability to be added, and I think what you notice in this one is that there's a lack of explanation in all of these cases. The doctor really just didn't give any rationale as to how they were combining them and why. So here, in opposition of the case that I was just talking about, is another situation where it's an orthopedic and a psychiatric disability. and he said that they were acting in synergy, but really didn't give any other backup information other than the fact that he just never ever uses the combined values chart. And so I think that kind of policy that he was working in, that he just never ever did use the CVC, made it so his justification and reasoning behind using it in this the addition in this particular case was no different than any other case. Next one that I'm looking at here is Leo, which under this particular situation, saying that the two different it was because there were two different body parts of the spine that were impaired. He indicated that because it was two different parts of the spine, they should have been added, not combined, without any other justification. Again, I feel like probably with a little bit of language or a little bit of effort on the applicant's part, he probably could have gotten some language out of this QME using the word synergy or synergetic effect between, the lumbar spine and the thoracic spine. Probably could have got him to a place that this would have been allowed. It doesn't seem, at least from what I'm seeing, that it takes a whole lot more effort from the doctor than just a little bit more of an explanation as to why. If you're looking at this Newberry case, the last one that I've got up here, the doctor provided no explanation why they should be added instead of combined under the CVC. And so this was thrown out, and they weren't able to proceed with that addition instead of CVC. Certain circumstances have come up where it actually ends up where you can combine some body parts and use the CVC on other body parts. And I thought these were actually fairly interesting. And it also brings in a little bit of how the judges can end up being involved as well. So here's a particular situation under Sweetman where the judge added the spinal and the wrist disability, but used the CVC to combine those with the sleep disability, because the sleep disability was entirely derived from, or basically was a compensable consequence of, the physical injuries. And so if you think about this particular situation, the doctor wanted to add all of the body parts, but the judge was able to step in and indicate which ones were or were not justified by the doctor's reasoning. Holquin is also fairly similar. The applicant's disabilities for the right and the left upper extremity were added, but the CVC was used to combine the upper extremity disability and those for the right knee and the psych. So again, you can see in this situation, they took into account the fact that the right and the left upper extremity to be added together, because they, having one arm disabled versus having both arms disabled creates, or disability in both, creates a much greater burden on the applicant's ability to do things than having one arm or both arms and your right knee or a psych issue. And this again is showing that the judge can actually come in and take a look at the justifications provided by the doctor and whether or not they're actually supporting the addition or the combined value of the permanent disability that has been provided, or actually impairment that's been provided and then adjusted out to permanent disability. And like I mentioned earlier, what's very important to think about all of this is that the CVC has been created and is important to make sure that at no point in time anybody is provided a permanent disability amount that exceeds 100%. So if the applicant's disabilities are added, they can't get an award that high, and we have case law that supports this. So some of the things we can take away from these cases is, the AMA guides nor the PD schedules mandates the use of either, but I do think it's important to note that there is a leaning towards the CVC, specifically under the AMA guides. It indicates that there is. And that judges can't unilaterally combine disabilities, but they can in order to make sure it's supported by substantial medical evidence. So they can't step in and change it, but they can make sure that things are supported appropriately. So a judge can't turn around and change what's happening, but they can adjust what the doctor has provided if it's going to be supported appropriately, because really it is the applicant's burden to show Kite is applied. And if they haven't been able to, based on the doctor's medical evidence that's been presented, then they get what is the standard, which is the combined values chart. Both the judges and the commissioners are basically looking at things as they come in. And I think I mentioned this earlier, they have different levels of scrutiny. So you're going to end up with different results depending on which judge you're in front of. But the hope is that the scrutiny that they give to each of the cases should be fairly similar. But again, you're looking at different people's opinions regarding how well a doctor is justified using terminology such as, synergy and things like that. And that brings us kind of to what can we do with this information? Because really the basic idea is that we're trying to stick with the CVC, keeping our PD levels down and knowing that it's up to the applicant to do it. Things like our advocacy letters going to the QMEs is a really good place. If you see an applicant's attorney sending out an advocacy letter that's referencing Kite, make sure to respond in kind, letting them know that the AMA guides actually prefer that you go with the CVC and that needs to be justified. If you do end up with a QME that finds on the side of Kite or that applies Kite, see if they've justified it well enough. Is it worth challenging? Should we set the doctor's depot? Figure out. Careful part about that, or the concerning part about that, is when you set the doctor's depot, you do give them the opportunity to further justify what they've said in their reporting. So there is always that kind of concern that if you give them too much of an opportunity, they may make their opinion stronger, not weaker. So there is that to think about. And let's see. I think that's it. We have a bunch of reference guides through my work. Feel free to reach out to me at any point in time and I can help you out. A lot of these reference guides that I have will help you go through some of the things that I was talking about with the PD ratings and timelines and things. Let's see, different work comp benefits and stuff like that. We have a lot of fun little cheat sheets that make things go quicker. So please feel free, reach out to me or email me. Here's all my fun information.
Wendy, did we have any questions?
We didn't have any questions, but I do want to let everyone know that the little snafu I had with the uploading of material, the handouts, we'll go ahead and email those to you. I'm sure everyone would like to have a copy of that. So we'll make sure to take care of that for you.
Absolutely. Nancy, you have such a nice way of presenting information.
Thank you.
It's very logical and easy to understand. And I wish every speaker had that particular gift. Well, speaking of gifts, we have 11 more webinars for you to follow. And so be sure to check the MacroPro website and they will all be listed there for you to see. I'm going to tell you which ones are coming up here soon if you'd like to participate. So the next one is going to be tomorrow, and it's going to be how to identify the real Santa Claus under the mistletoe. And that's going to be on how to do investigations and using those early onset investigations with records in order to determine either the value of the claim or see if there's a way that we can shut down that claim. And it'll be my pleasure to be speaking tomorrow morning with Chris Champlin, who's outstanding. If you heard him, you know he's kind of the Robin Williams of the industry. And then we have civil money penalties that are coming up also tomorrow at 1:30 p.m. So make sure that you follow that. Plus we have another, it's not an encore presentation because it's not exactly the same, but it's what you should know about applicant copy services. And that'll be on the 13th at 10 a.m. So if you haven't signed up for that, please do. We have three people from the applicant world that is going to be talking about what they do, how they do it, why they do it, and hopefully you have any questions, I'll answer those. So until the next time, please go on to macropro.com and sign up for all the other classes. Nancy, to you and your family, happy holidays, and to all of you in the virtual world, we wish you great peace. Bye-bye now.
Bye, everyone. Thanks, Nancy.
Hi, all. It was a pleasure.